A very good morning to all the viewers of KCGC TV. I am Assistant Professor Gurjinder Kaur from Khalsa College of Law, Amritsar. Today, my topic of discussion is legal and procedural aspect of international adoptions in India. As we all know that parenting is an essential aspect of our evolutionary heritage. This enduring mutual relationship of care and affection establishes a phenomenal aspect of a non-institutional care, that is, adoption. In its true legal sense, according to Section 2, Clause 2 of Juvenile Justice, Care and Protection of Children, Amendment Act 2021, it formulates a process by which a child is permanently separated from a biological family and is established in an adoptive family with all the rights, privileges, and responsibilities which are attached to a biological child. Therefore, the great impetus was given to the international adoptions, which was seen as a best alternative for the domestic adoption for the common form of family formulation. International adoptions etymologically refers to a term and a process whereby a couple or an individual can adopt a child from a different country. This is also known as intercountry, transnational, transcultural, cross-border, or foreign adoption, because the adoptive parents and adoptive child, they both belong to different countries and nationalities. Although the history of international adoptions is traceable to the antiquity, but the surge of this has happened only after the World War I and World War II, because it caused political, social, cultural, economical, and human unrest in the developing and the underdeveloped countries. In India also, this process was known since 70s, but was highlighted and became famous with the case of Lakshmikant Pandey versus Union of India in the year of 1984. This case was basically a writ petition which was filed by a very vigilant advocate named Lakshmikant Pandey, revealing the plight of the young toddlers, infants who were tortured, abused, forcibly labored, and trafficked under the garb of international adoptions. So the Supreme Court of India, in the series of judgments from the year 1984 to 1991, has given various kind of guidelines, norms, which are to be processed and followed for international adoptions. With this, the prominent directions were also issued to the Government of India to establish a nodal agency which can regulate the process of adoptions here. Consequently, the present state of legal provisions and procedural aspect has been established through these judgments. And we have a nodal agency known as CARA, which is Central Adoption Resource Authority, working under the aegis of Ministry of Women and Child Development. CARA is an autonomous and statutory nodal agency which is proceeding with international adoptions by its own regulations, following the various legislation which are subcategorized as: first, Juvenile Justice, Care and Protection of Children Amendment Act 2021 with its model rules of 2016 and 2022. Hindu Adoption and Maintenance Act of 1956. Guardians and Ward Acts of 1890. CARA Regulations of Intercountry 2022. It is pertinent to note here that Juvenile Justice Act and the CARA regulations are the main formulations through which process and procedure of the international adoption is being done. It also facilitates the individuals belonging to the different religion for foreign adoption taking resort of their personal laws such as Hindu Adoption and Maintenance Act and the Guardians and Wards Act. So the main focus here will be on the Juvenile Justice Act and the CARA regulations of 2022. International adoption under these are governed by the fundamental principles that every adoption must be in the welfare of a child so that he or she can develop to its full potential. Preference must always be given to the person of Indian origin so that a child must be accepted in the social cultural milieu. And every adoption must be done through the online database of CARA, that is Carings, so that secured and safe international adoptions could be done. Now let's discuss a few highlights of the Juvenile Justice Act and the practical procedure of the international adoptions. Firstly, under the Juvenile Justice Act, any person, irrespective to the religion to whom, firstly, person belonging to any religion can adopt a child under this act. Secondly, when an adoption order is finalized, there is no need of the adoption deed. Thirdly, under this act, a very prominent feature is there by which step-parent and the relative can also adopt. Any orphaned, abandoned, surrendered child can be rehabilitated if the adoption process could not be completed. Inbuilt mechanism has also been developed under this act through Juvenile Justice Board, Child Welfare Committees, District Child Protection Unit, and Child Care Institutions, where the help of the judicial magistrates and executive authorities of the state are also taken. Beginning with the practical procedure of the international adoptions, the initial step is the counseling of the prospective adoptive parents by the social worker of the authorized foreign adoptive agency. After this, a home study report is prepared, which is taking into consideration the social, mental, physical, and financial stability of the adoptive parents. If the assured report are there, the next step is the registration of the adoptive parents on the online database of the CARA, that is known as Carings. After this, in the next stage, the prospective adoptive parents select a child which is referred to them, and after the completion of the process, no objection certificate is issued by the CARA, following by the adoption orders, conformity certificate, passport, and visa exit for the child. So this was all about the legal and procedural aspect of the international adoptions in India. Thank you.